Good afternoon, everyone. I'm Judge Joel Chupak. Welcome to the Real Property Law Committee meeting for December. With me is my Vice Chair, Nick Tiska, and our presenter today, Jeremy Baker. I'll turn it over to you.
Thank you very much, Judge, and I want to thank the committee for this opportunity today. So what we're going to be talking about today, even though it has a real transactional bent, it's design and construction contracts and related issues, there really is a dispute resolution and litigation overtone to it all, because in my experience, when you have thoughtful project delivery methods and good design and construction contracts, you tend to create situations where you can achieve early cost-efficient dispute resolution if there is a dispute. And that is sort of a thesis for the presentation, but it's sort of a thesis for me that I'm trying to prove maybe over the next decade. I have no empirical data to support this, but my belief is that if you were to conduct a postmortem on every protracted piece of litigation that goes nowhere for years, you could probably trace it back to a faulty project design, the wrong delivery method, the wrong contract, the wrong insurance. And so even though this is a presentation that is going to be about design and construction contracts, which I handle a lot, I am a litigator and I am very interested in early cost-efficient dispute resolution. One of my mentors once said something to me, which I'll never forget. He said that smart business people are beginning to ask why they're paying their lawyers so much to prepare for trials, which seldom occur. And I think that that is the way that a lot of real estate developers and property owners and other clients are beginning to think. And so, without any further delay, I'm going to get into my slide deck, which is ambitious, but intended to serve as notes in the event that you're not able to take down some of the information that I'm going to cover. As the judge mentioned, I'm looking to make as many friends as I can in the community, so I would welcome you all to reach out to me if you have questions. And I'd also point out that if you do download the materials, they have a lot of clickable links inside that would take you to many other videos that I've recorded on some of the subjects that I'm going to cover today. So if you do have any questions, perhaps you'd consider those as resources. And without any further delay, I'm going to see if I can not mess up the effort to show my slide deck. Judge, does that look good? Can you see it? Okay, I'm going to assume that
yes, all is good.
I'm assuming you can see it. Thank you. So this is construction contracts primer, what real estate attorneys should know. And so, real estate law and construction law are different, and I'm not sure that a lot of people appreciate those differences. We're going to talk today a lot about project delivery methods, which may be a term that is unfamiliar to you, although I bet that you probably dabble in project delivery methods perhaps without knowing it. We're going to talk about design and construction contracts and all the reasons why. If you view it as a fill-in-the-blank exercise, you might be doing your clients a disservice. There is a lot of intra-contract coordination that needs to be thought through in terms of having the right dispute resolution methods, intellectual property terms, insurance indemnity. They all kind of work together in a web. And I'm going to use the example of the way that mechanical, electrical, plumbing, and fire protection systems these days are delivered on many projects. Many of you know that it's common for those the design function to be performed by the same contractors that are doing the actual construction work. So it's a design build MEPFP under the general contractor. And that is a real good illustration for some of the problems that you can experience on these projects if you don't think about the way to properly align the chess pieces on the board. And I'm going to talk about standard contract forms and also custom contracts. When I took the bar exam, I preferred the multiple choice section because I hate looking at a blank piece of paper and wondering what needs to be on there. And I think with custom contracts, one of the problems is it's hard to spot what's missing. It's those Rumsfeldian unknown unknowns. So I don't necessarily have a preference for standard forms, but when you use them, picking the right one and understanding that they're really not ready to use in a fill-in-the-blank way, but just a starting point for customization is the right way to be thinking about those standard forms. So, I'm not a real estate lawyer. And I think that many of the people on the call are. I've never handled a lease. I've never done any zoning or entitlement work. I don't arrange construction financing. I am a construction attorney, but I think that I serve many of the same clients as a lot of the people on the call. One of the biggest honors of my career is I'm a liaison to the AIA Contract Documents Committee, which is a fancy way of saying that when the AIA is writing their new contract forms and they reach out to a wide swath of people in design and construction, contractors and designers, they also ask for lawyers for input on forms as they're drafting them. And so I will, on occasion, have the opportunity to say, this is what I like, or this is what I don't like about the not yet finished new versions of the AIA contracts that are released. I'm also a former adjunct professor of construction law at John Marshall. I taught there for several years until they were absorbed by UIC, and that is a 30-hour lecture. And so what you're going to be getting today is maybe 1/30th of that class. And I've only been a solo lawyer for about 13 months. Most of the last 15 years, I was at Schiff Hardin, where I was a partner in their construction law group. So today's agenda is these 4 points. And what I don't want to say irks me necessarily, because I'm always honored to hear from real estate developers and property owners that want me to help them out. But what might irk me a little bit is that they always want to jump to number 4. They come in and they say, I got a project, it's already halfway baked. Here's a contract form that we're going to use. The other side has already put in their terms. Now you need to go ahead and comment and make it better. And what, is disappointing to me is that so much of the value that I can add, which we're going to talk about today, is in the first 3 phases. And while the second thing on the agenda, the insurance ramifications, is really not negotiable, and I'm going to insist that that be right, no matter what the project looks like when it comes to me. A lot of times the project delivery method is already selected, and maybe it's the wrong one for the project for a variety of reasons. And the way that the parties have chosen to arrange their pricing arrangement, maybe it might not be the best one for my client, but in some cases it's too late to go backwards. So we're going to go through these first project delivery methods, and then I'm going to explain how the way that you arrange the chess pieces on the board has insurance ramifications. We're going to talk about pricing and procuring design and construction services. And then at the very end, we're going to actually look at design and construction contracts. So first, project delivery methods. I like this picture because all those different sorts of screws, it's a metaphor for the many different kinds of project delivery methods. I think there's a joke in here somewhere about, getting screwed if you don't understand project delivery methods, but I'm still working on the punchline. So we'll let that rest for now. And with this slide, I think we're starting to get a little bit closer to some of the things that maybe real estate attorneys would recognize. These are some common project delivery method variations. And, even though these may be terms that you're familiar with, perhaps not everybody is deeply versed in their advantages and disadvantages and why a real estate developer or property owner might prefer one rather than the other, which we're going to talk about today. I love diagrams, so you're going to see a lot of diagrams in this presentation. And when you see a line, that represents a contract. And so this is, a pretty standard project delivery method. And the reason why we diagram not just, the way that the parties have chosen to arrange their various contracts, we don't just need to be concerned about who the parties are and how they're contracted. We need to be concerned with what they're doing. And so if you look up in the upper right-hand corner, you'll see that this common arrangement where the owner separately hires the architect or lead design professional under one contract and then has a separate contract with the constructor, the general contractor, very common. If this is what your clients are doing, this is probably the easiest to get right. And this is typically an arrangement that you would prefer in a design bid build arrangement where the design is completed and then the drawings are put out to bid, or perhaps subject to some negotiation, and then the construction follows. And so, there are advantages and there are disadvantages to this project delivery method. One of the big advantages is if you are only an occasional or perhaps unsophisticated consumer of design and construction services, you do not do this much. if you're the project owner, it can really help to have the direct contract with the architect, because the architect can play a big role in keeping an eye on the contractor and doing things like reviewing payment applications, observing the construction, as it proceeds. And, I don't want to say tattle in a pejorative way, but, tattle on the contractor, if they're looking for more money than they're entitled to, or they're presenting a change order that wouldn't be appropriate, because the architect owes its duty of loyalty to the owner under this arrangement. That's one of the major advantages. Another one is that, this is so common, the marketplace is comfortable with this, because the plans and specifications are typically complete before the bidding or negotiation phase where the contractor is hired. You tend to not only have more accurate pricing, right? Because the contractor doesn't have to wonder over what the designer's intent is. They've got this completed set of drawings. So the contractor doesn't need to put in a bunch of pricing contingencies, for I don't really know what the architect means here, so I better add another 1%. They can give you a better price. So pricing tends to be more accurate. And when you have well-detailed design drawings, perhaps the odds of, less design defects are going to be an advantage as well. What are the disadvantages? Well, there's a big movement over the recent decades to have the contractor involved in the design phase, so that the contractor can be whispering in the architect's ear about issues of cost and constructability, which, perhaps the design team is not going to be totally clued in on. So you don't have a lot of contractor input in the design phase, and you have a slower delivery time, right? Look in the upper right-hand corner: design, then bid, then build. These are sequential, okay, in the sense that they're back-to-back phasing. So if you represented a developer that says, I got a tenant, I got a lease, my project has got to be finished in a short time frame, or they come to you and they say, my JV partner, for a variety of reasons, needs a shovel on the ground in a month, and the design's not going to be done, this might not be the most appropriate delivery method for you, because you've got that back-to-back phasing and that slower delivery time where the design gets completed, and then the bidding or negotiation happens, and then construction. Also, you have this adversarial relationship between the contractor and the architect. And, we don't talk about it in those terms, but that's really what it is. It's an intentional adversarial relationship where the general contractor is going to come to the owner and say, oh, there's a big design problem, look out for this, there's going to be a change order. Or the architect's going to say, what do you mean, you want 30%, and this payout for framing, there isn't a window out there. And so there's an intentional adversarial relationship, which isn't a bad thing. Again, if you're an unsophisticated owner, it is a great advantage to have an architect there to whisper in your ear. And so those are some of the advantages and disadvantages, and I've listed them out on this page. I'm not going to repeat them here right now. These are really intended more as notes if you wanted to save this PowerPoint, which you can download from the CBA website, or shoot me an email. I'll send you a copy. Hopefully these will help you remember some of these points in the future when you're thinking about it. So if we talk about the speed of delivery, what you have at the top of this slide is the traditional method, is what we just talked about, where you design and then bid and negotiate and then you build. And you can see that the length of the project is longer, the duration. And so there are ways to fast track projects where the pricing exercise can happen simultaneously with the design phase. And you can even have the construction begin in some instances, civil work, site work, perhaps pouring foundations before the design is entirely complete. And so while there is a real advantage for delivery speed, if you, again, have a client that says there's a pressing need for me to have this project done quickly, you need to be thinking about how do you arrange, the chess pieces so that you can fast track the project. Now, of course, the downside of fast tracking is a loss of control, because if the pricing exercise is going on before the design is done, the pricing exercise is probably not going to be as good. And of course, if you pour foundations and start erecting steel on a complicated project, and then you realize that there was some, design assumption that wasn't accurate, that gets worked out by the time the drawings are complete. If you've started construction, you can have, change orders, claims, and all sorts of problems. And so you suffer sort of this loss of control. And one of the reasons why I'm a big fan of the next project delivery method is that you are able to get some of the fast tracking without the loss of control. And this is the design build project delivery method. And the hallmark of this is that the owner hires one party to perform both design and construction services. And there's a lot of different ways that you can have a design build project. You can have a design builder that is got in-house design capabilities. Maybe they've got architects and engineers on staff. Or you can have a joint venture between a construction company and a design company, or a dozen other variations of what could fall under what we consider design build. But what really makes it a design build project is if you look at the line between the owner and the design builder, there's just one contract for everything. And so look at who the architect works for. It's not the owner, okay? And so is that a good thing for the owner? It could be, in a sense, because single point responsibility, right? You only have to sue one party for, whether it's a design problem or a construction problem. If you're the owner, you don't get the contractor and the architect doing this kind of thing where they're pointing at each other, arguing that the other is to blame for a problem. But you also don't have the architect owing its duty of loyalty to the owner, because the architect works for the design builder. And so if you, again, are an unsophisticated consumer of design and construction services, and you need the benefit of having a design professional to whisper in your ear and say that pay app is overstated, or there's something I'm seeing in the field that I don't like, you lose that if you go with design build. But if you look up in the right-hand corner and you think about not just who the parties are and who is contracted with whom, but what they're doing, you have the potential for faster project delivery. You can have this fast tracking without the loss of control, because a good design build project involves the parties learning new relationships, learning new ways to work with one another, right? So the architect and the general contractor ought not to consider themselves as adversaries here, because they're not set up in that way under the arrangement where the owner separately hires them. They really need to work very closely together. And a good design build project where you were able to take advantage of it, you've got the designer and the contractor that have cast off that adversarial mentality, and they're going to work very closely together even during the design phase. And so while I'm being facetious when I say that, the architect could almost have the general contractor sitting in its lap while it's going forward, that's kind of the idea. I like to see the design professional invite the contractors in, talk to them about cost and constructability, invite the vendors in to meet the architect and think about how the design can be bettered. And this is one of the advantages of the design build method of project delivery is you've got, these close relationships. The contractor and the architect are not adversarial. Of course, the architect is not policing the contractor for the owner, but, that's, everything's push and pull. There's pros and cons. You got the faster project delivery, the fast tracking without the loss of control, and also earlier and greater price certainty, right? Because the contractor's not waiting around for the design to get done before the pricing exercise. The contractor is able to call up the architect and say, hey, what is your design intent here? Because I don't want to have a financial contingency in my contract. I don't want to add dollars in that I don't need. Just tell me. What is your intent with this? And so, you've got better communication of design intent. The owner's not going to be facing change orders if there's a problem with the design, right? Because that's going to be the design builder's problem. So that's an upside for the owner in addition to that single point responsibility. But also these new relationships facilitate the use of three-dimensional design, BIM, building information modeling, Revit, where you're not using AutoCAD and creating a two-dimensional model, but rather a three-dimensional building information model composed of model elements. And the authors of those model elements can be not just the design team, but the contractors, particularly when you get into shop drawings, in the more advanced phases. And so there are a lot of advantages to design build. I'm a big proponent of it. Again, here are some of the things that I just mentioned. I'm not going to repeat them, but just think about them as perhaps notes that you can come back to in the future. And the most common kind of design build project is where you have the general contractor serving as the design builder. And it's kind of an historical accident that this is the way that most design build projects are run. Architects have a lot in common with lawyers. We're professionals, and what we're good at, or maybe not so good at, is looking at a scope of work and trying to figure out how many hours it's going to take to execute on it. And so design professionals are a little bit risk adverse in the sense that they're just not used to, they're not taught what they need to do to guarantee price and schedule. Contractors, on the other hand, tend to be much more entrepreneurial because they're in the business of guaranteeing price and schedule all the time. And so you tend to see most design build projects with the general contractor in the lead, which, many people would say that's appropriate because when it comes to worrying about, dollars and cents and cost and constructability and getting the project done on time and on budget, a lot of people would say that, it's an advantage to have the contractor in the lead. I don't disagree with that. I do think that when the owner is weighing trade-offs between cost and constructability and the wisdom of value engineering choices, if the general contractor says, hey, sure, I can bring it in on budget, notwithstanding all those unexpected change orders, but we're going to cheapen the mechanical system. The architect and the engineers might think that that is a horrible idea, but to some extent, they've got a conflict of interest because they work for the design builder. And so they're muzzled and they can't necessarily bring that good advice to the owner. And so if the owner is going to do a design build project and they want the general contractor to be in the lead in the design build team, they got to understand that there are trade-offs. I think that there's a pretty good argument that when it comes to weighing building performance over decades, cost and constructability, value engineering changes, that maybe a design professional is better equipped than a contractor to advise the owner on those sorts of issues, which is why I'm a big proponent of designer-led design build, which is not something that you see very often because it takes an entrepreneurial architect that can understand that even though people like me tell them don't make guarantees, don't make warranties, stay within your professional liability insurance, there is a way to structure the relationships such that they can not take on more risk than they've bargained for. And so I'm going to toggle back to the last slide real quick, just to show you that there's another party involved here. There's another box, okay? Because you would never have the design firm lead the team. What you'd have is the design firm would set up a separate LLC to carry the construction risk. That would be the design builder, and it would hire the related design firm so that the architect and the engineers can do the sort of traditional things that they would do without running into more risk. And so I teach designer-led design build. I've given speeches about it everywhere from Washington State to Missouri to Florida. I think it's fantastic. I wish more entrepreneurial architects and engineers would think about this. There's tons of advantages to owners. And one of them is that if you stop and think about it, when you're an owner and you hire a contractor, design builder, how are you really going to know what you're getting in the project? You're not necessarily going to be sitting there with the lead design professional going through all kinds of programming and talking about exactly what it's going to look like. There's a little more of a veil over the eyes of the owner when they've hired a contractor to design build in terms of making sure that the owner gets exactly what it wants in the design, which is why, as I toggle to the next slide and we show again the traditional way of doing it with the contractor in the lead, sometimes an owner might want to have a consultant that works directly for them, that is sometimes referred to as a criteria professional, that is going to have a direct contract with the owner. It's typically an architect or an engineer that's going to have a strong understanding of building performance and construction, that's going to work with the owner to develop an exhaustive list of criteria for the finished project. That developed criteria is often stated as a performance specification, which would define what a successful project outcome looks like and guide the contractor design builder on what the design needs to look like. And that criteria is often incorporated into the design build contracts as a performance specification. So, what that might look like is the owner not just knowing that the general contractor is going to be buying for it an Acme model 150 18-ton chiller and not have any idea about what its performance is going to be like, it would look like the criteria professional specifying that, it needs to be one that is capable of maintaining an interior temperature of 76 degrees Fahrenheit, while the, outside temperature is 100 degrees Fahrenheit. That would be the example of a performance specification. And, in many big projects, you would have a criteria professional maybe even do the first 30% of the design before they hand it over to the general contractor to go to its architect to complete the design. Sometimes that's referred to as bridging documents. But if you're the owner and you're in a design build project, you need to think about how much are you losing to not have a direct contract with the designer, and what do you want to do to maybe cover some of those risks. And then the criteria professional would ultimately observe construction and, ultimately witness, performance tests, in order to make sure that what was specified, is brought about. So there's all kinds of different ways to arrange the chess pieces on the board. And these are things I wish that real estate developers and property owners and their attorneys would spend more time thinking about. Again, here's some of the advantages of a criteria professional. I'm not going to dwell on this again. But the next project delivery method is multiple prime contractors. And you can see here that there is no general contractor. Here, the owner acts as its own general contractor. There's no role for a traditional general contractor. If the owner's a hospital, they might not want to have the hospital sign the contracts directly. So sometimes they'll have a single purpose LLC or something like that that serves as a general contractor entity. And this is going to save the markup on that the general contractor is going to put on the construction costs. But you got to ask yourself, what do you lose? Because in this case, the owner is ultimately liable for management and coordination problems. And so if you have all these multiple prime contractors saying that, that one got my way, and I was supposed to have use of the laydown area this week, and I got 18 trucks of steel showing up, but there's another contractor in my spot. What are we going to do, owner? This is where you lose the management that a general contractor brings to the table. And if you think about it, most general contractors sub out all the work anyway. They don't do a lot of performing the work with their own forces. And so really what a general contractor is sort of a construction manager, a professional manager. And so if you're going to go this route, something that you may wish to consider if you're an owner is hiring a construction manager to whisper in your ear and to give you some good information. And we're going to talk for a moment about, what that might look like. Here are, some of the points that I've just covered. But if you look at the bottom, you can really get creative with construction management, which is what I'm going to transition to in a second. I was involved in a mega project. It was about $800 million. And the owner, it was a very complicated project mechanically. The owner was very interested in making sure that there were going to be payment and performance bonds to backstop the performance of the prime constructors, and their subcontractors. One of the problems, though, is that there's not many construction companies in the United States that have bonding capacity for an $800 million job. And so you're going to have to go to, a handful of contractors nationally. What the owner decided to do instead is to go multiple prime contractors and split the $800 million project into 4 $200 million prime agreements. And because this was a very mechanically complicated project, the construction manager that they hired was actually a joint venture between a construction company and an engineering company, because that was the sort of expertise that was necessary on that project. So you can get very creative with construction management. Okay. Again, multiple prime contractors is compatible with this construction manager as advisor delivery method. This is what it looks like. The owner is going to have the construction manager as advisor whisper in their ear. And, there's a whole lot of different variations of construction management. It's not really one project delivery method so much as it is a wide spectrum of possible options. If you go all the way to the left on the spectrum, a construction manager as advisor, all they're going to be providing is a layer of consulting, coordination, and management for a fee. They're not going to be in contract with the constructors and the subcontractors, okay? But if you go all the way to the other side of the spectrum, a construction manager as constructor It's very much like when an owner hires a general contractor, because the CMC is going to hold the contracts with all the trade contract and the subcontractors. And so what's the difference between hiring a general contractor versus hiring a construction manager as constructor? It typically is that the CMC is involved in the design phase. Okay. And so they're going to be providing that expertise. They're going to be whispering in the architect's ear about cost and constructability, and don't use that vendor, use this vendor. This is a better supplier for the roof. And so there's a real, I think, commonly accepted belief these days that it's an advantage to have a constructor involved in the design phase. And, this is an option. The key question to determine, where we fall on the spectrum is who is going to hold the contracts with the various trade contractors. And I could put another hash in the middle of this spectrum for, agency CM, which is where the construction manager will sign the contracts, but it'll do it as the identified agent as the owner. So the owner will technically be in contract with the trades, even though it doesn't sign the contract. So a wide spectrum. Again, this is what it looks like. CMA, Construction Management as Advisor. Okay. Again, this is not where the CMA is necessarily going to be liable for the mistakes of the architect or the contractor, because they don't hold those contracts. The CMA does things that are design professional-ish and carries design professional-like insurance, but they also do things that are contractor-ish, and they tend to carry contractor-type insurance as well. And when I click onto the next slide, you're really going to see the difference between CMC and CMA visually. It's very easy to understand. Here we go. Watch what happened. Okay. General contractor disappeared, and the CMC is in the chain of contract because, again, it is going to hold the trade contracts, with the subs and the vendors. It is much like when you hire a general contractor. It's just that the CMC is involved earlier in the project. And so I'm going to transition now to the next part of my presentation in 1 second here, where we're going to talk about integrated project delivery. This is not something that I think most of you will ever deal with. Again, integrated project delivery, it's a spectrum. It's very cutting edge. If you go to the left side of the presentation, a light IPD project is a lot like design build, and there's not a lot of risk for the owner. If you go way to the right side, okay, and you have a fully integrated IPD project, you've got high risk and reward for the owner, because in some instances, you're going to have the architect, the contractor, and the owner all sign one agreement. Okay, stop and think about that for a moment. All right, we've all seen, loan agreements where there's lots of signatories, but it's more like the lender is blessing something, or there's an assignment and someone's acknowledging it. That's not what I'm talking about here. A fully integrated IPD project has one contract with more than 2 contracting parties. And so that is really revolutionary. It is legally and contractually very complicated, and probably not something that would be a great option for most projects. And so as we transition out of the discussion about project delivery methods, if I can get people to remember only one thing, it's that this always comes first. If you are the owner of the project or the real estate developer, think about how you can arrange the chess pieces on the board to suit your particular project goals. There is no one size fits all. There's no one best option. But that being said, when I have an owner or developer come to me in the early stages and they say, I just have this seed of project that's germinating in my head, I'm going to say, what's most important to you? All right. Do we have to complete this project quickly and fast track it? That's going to send me in one direction. Okay. But if they're really concerned about not running over a certain price point, that's going to send me in another direction. And if it's something that's very mechanically complicated, like food manufacturing facility that's subject to FDA regulations with various, negative pressure environments and, all sorts of things, you want that design completed before somebody starts, erecting steel and pouring concrete. So, there's all sorts of certain goals that can be served here. And I hope that more owners and developers in the future think about how to arrange the chess pieces on the board before they leap into, okay, let's pick a construction contract. Because the way that you arrange the chess pieces on the board has very substantial insurance ramifications. Okay. And, that's what I'm going to pivot to talk to about right now. Okay. Because how the chess pieces are arranged on the board, who contracts with whom, and for what work or services is going to dictate the right way for you to arrange insurance. And we're going to talk at the end of this segment about how it's great to have good insurance, but if you do not have the construction and design contracts, which marry up with that insurance, you're not going to have a successful outcome, because there is a very close relationship between the terms of design and construction contracts and the insurance that should be brought to the table based on what project delivery method we're talking about. So, again, I negotiate a ton of construction contracts. I am a transactional lawyer by any stretch of the imagination, but I think that if you were to ask the people at Schiff Harden, where I worked for most of the last 15 years, they tell you that they think of Jeremy Baker as a litigator, okay? Because I long since lost count of the number of state and federal jurisdictions I've litigated in, the number of depositions I've taken, but it's very substantial. And I think that really helps me, because I negotiate contracts with a litigator's mind. I begin with the end in mind. I think about, on behalf of my owner and developer clients, here's a dozen things that could go haywire on the project. And if that happened, how would I make my claims? And would there be insurance or some other pot of gold at the end of the rainbow to backstop the claim? And so I think that you got to begin with the end in mind when you're negotiating these kinds of contracts. And, I'm going to show you another slide. This is the first one that we looked at. It's the traditional structure where the owner separately hires the architect and the general contractor. And I want you to look at the bottom of the slide now. This is the, example that I noted at the beginning of the presentation that I was going to use about how common it is these days for the mechanical design to not be done by an engineer hired by the architect, and the electrical design to not be done by an electrical engineer hired by the architect, and the plumbing design to not be hired by a mechanical engineer under the architect, and for the fire protection system design to not be hired out under the design team, but rather the mechanical contractor that's going to build the mechanical systems typically will design it. Okay. And so you have MEPFP, design build. You have a little design build project that's nestled inside your traditional structure. And so the litigators out there, and Judge Chupak, are going to understand immediately the problem with this when I say three words: economic loss doctrine. Okay. And so for those of you who are not litigators, and for those of you who, like me, took Barbary some 20 years ago, just as a refresher, the economic loss doctrine is sort of the dividing line between contract and tort. We all know that if you go to Best Buy and buy a TV, a Samsung, you're not happy with the color, you can't sue Samsung for negligence. Okay. Your remedy is in contract with Best Buy. But if its TV burns down your house, now you have a tort claim. And so if we look at this diagram and we think about what happens if the mechanical system underperforms, okay, and you've got a 7-figure problem that needs to be fixed, okay? What happens if, the electrical system is, not to code for some reason? What happens if, when the project's completed, you realize that, the riser for hot water and for cold water, they were switched, and no one caught the design problem? Well, you've got a design defect that was committed by somebody that works for the general contractor, okay? And the owner is not necessarily going to be able to bring a direct claim against the mechanical engineer that did the design work, all right? So, those of you who maybe are not litigators are thinking, no big deal, I'll just sue the general contractor for this. And that's, you can do that. That is true, because they would just third party in, the MEPFP designer that made the mistake, okay? But if you do that, what you're going to get is protracted litigation for years, and it's totally avoidable. There are ways to put terms in the general contractor's agreement that cover insurance and other things. And there are ways to put terms in the subcontractor's agreement that cover insurance and other things that would enable the owner to go directly to the designer the MEPFP designer, bring a claim directly against them, even if you don't have that sudden calamitous event that's going to give you the tort claim. Okay. And when you can do that, you can go right to the person that made a mistake, and you can, if you're smart about the way that you arrange the contracts, you can find the right kind of insurance waiting for you, and you can get into a mediation. Okay. And you can achieve early cost efficient dispute resolution. But if you're the owner and you got to sue the general contractor for a design problem their subcontractor committed, buckle up for a couple of years of litigation, because general contractors may not have the right kind of insurance to cover the design claim. And certainly if you as the lawyer that's negotiating the contract didn't make it so that they do have the right insurance, they're probably not going to have it. And believe me when I tell you that it's going to be very hard to get a GC to settle an uninsured claim for a design mistake made by one of their subcontractors. I say this with love about my contractor friends. I say this out of respect that they know how to squeeze the life out of a penny and a nickel and a dime better than anybody else in design and construction. Okay. They're not going to cut you a check for 7 figures under these circumstances. I mean, it's about as difficult, trying to get that kind of a money from a general contractor as it is trying to stake a vampire. Okay. So as people who negotiate these design and construction contracts, we can do it the right way, and we can begin with the end in mind, and we can begin with a litigator's mindset and get the right insurance terms and the right other terms in the prime agreements and the sub agreements, or we can, not do that, hope everything goes well. And then if there's a problem like this, trust that probably your owner client's not going to realize that there was a shortcut that they would have had if only you maybe negotiated the contract a little bit differently. So you got to negotiate these construction contracts with a litigator's mentality. And you got to understand the paradox of insurance, because insurance and construction contract terms, they interplay off each other, and wrong construction terms can destroy coverage, and the right construction terms can be an essential ingredient to insurance coverage. So let's take the example of design professionals. Let's talk about professional liability insurance in architects and engineers, because there is a very acute risk. Okay, if you are the owner or developer that is negotiating the owner-architect agreement, if you're the lawyer for the owner, okay, and you win, I'm using air quotes here, you win the contract negotiation with the architect by forcing upon them terms that are uninsurable, okay, you didn't win the negotiation so much as you just threw away the professional liability insurance coverage that could be there to protect your owner or developer client. And some people are saying, oh, well, professional liability insurance, that's for the architect or engineer. I don't really care. And yes, of course, that insurance does provide defense indemnification and protects the design firm. And yes, I have seen really scary claims where you got a design firm with $5 million in coverage, they got a $20 million claim. I've been in the uncomfortable meetings when I was a big law lawyer where I would bring my bankruptcy lawyer partners in tow with me to the design firms to talk about how they might go out of business, as a way of dealing with the claim. So yes, that insurance is there for the designers, but what owners and developers don't understand well enough, and this is, if anything makes me crazy, it's this, because I have to talk about this every week of the year. Professional liability insurance also cuts settlement checks to owners and developers, okay? And so it is nonsensical for an owner or a developer or an architect or an engineer to have uninsurable terms in that professional liability, the professional services agreement. And what you need to understand is that most of the money in a construction project flows to the contractor. They've got the labor, they've got the steel, they've got the concrete. A very small amount of the money flows through the design firm. And so if you think that there is a design firm out there that is sitting on a ton of cash that is going to be able to cut a settlement check for you, if there's no professional liability insurance, think again. One of my standard lines for years, when I was running into this problem and trying to negotiate my way through it, is to say to the owner or developer's lawyer, when I represent the design professional, if you bring a claim against my client that's uninsured, you know what you're going to get? You're going to get to take over a really nice office lease, and you're going to get a lot of used computer equipment. But I don't say that anymore because most of my design professional clients lease their computer equipment. So all you're really going to get if there's no professional liability insurance to cut a check to the owner is, a bankrupt design firm and maybe the right to take over a lease and very, very few assets. So you got to be careful. Design professionals shouldn't warranty or guarantee the outcome of a project, because between every design professional and a finished project, there's a contractor. So they can't guarantee your owner or developer client's going to be happy. There's no insurance for that. Design professionals cannot defend other parties, so in an indemnity clause, you got to take that defend language out. Now, they can indemnify for attorney's fees, and that's slicing the bologna very thin, I realize. But you also got to watch out for prevailing party clauses, which tend to be uninsurable. So the paradox of contract language is it can destroy coverage, but it can also trigger coverage. It can be required to trigger coverage. And a good way to think about it is a contractor's defense indemnity obligation. Now, do you really want a contractor to defend and indemnify your client in the event there's a claim? Not really. You want their insurance company to do it, right? You don't want a construction company to be in charge of the defense. That's not what they do. They build things, right? And so if you have a good defense indemnity clause in a construction contract and you got the right insurance terms, the insurance is going to backstop the contractor's obligation. And if you do it right, you're going to get an adjuster assigned to you from their CGL insurance company that is going to assign a lawyer for you and mount a defense for you. So you want that defense indemnity obligation, not for itself, but because if you backstop it with insurance correctly, you can really have good value. And so, of course, I'm getting to the idea of, additional insured coverage, which is much misunderstood. A lot of people think, hey, get me a certificate of insurance which shows that my client is an additional insured under the GC-CGL coverage. And I'm not trying to tell you that you don't want that. What I am trying to tell you, though, is that it confers no coverage. Those certificates of insurance are, in a sense, almost worthless because they're a snapshot in time. If the coverage exists on Monday and the contractor is able to give you a certificate of insurance that shows that your client's an additional insured, but they stop paying their premiums on Tuesday and the policy is canceled, you get nothing. And it's not like in Back to the Future where Marty McFly's family began to disappear off the photograph. The ink on the additional insured, the certificate of insurance that says that your client's an additional insured, it's not going to disappear. It's just going to sit there in a drawer until you want to pull it out. And then you realize that there's no coverage there because additional insured, statements and certificates of liability insurance confer no coverage. You really want to be much more interested in what the additional insured endorsement says, okay? Because that is what confers coverage. And that is where sometimes the language in the construction contract, if it's not just right, you could find that you're really not an additional insured, even though you happen to hold a certificate that says that you are. Because if you look at these endorsements, you will sometimes see language that restricts the coverage to what is required by a contract. So, if the coverage that we provide to the additional insured is required by a contract, then there's additional insured coverage, okay? But if there isn't, if there is no obligation in the contract for one party to name another as an additional insured, it doesn't matter what your certificate of insurance says, okay? You're going to be denied additional insured coverage. And some other endorsements will say that, if you have to provide additional insured coverage by contract, the most we're going to pay, is what was required under the contract, or the available limits under the declaration, whichever is less. And so contract terms and insurance work like this, okay? They're flip sides of the same coin. And you're not going to be good just to have a certificate that says your client's additional insured. You have to get deeper, okay, into this. And if you represent an owner or developer, you need to understand that it's incumbent upon you and their insurance broker to dictate the insurance requirements that need to permeate the whole project, because the owner or developer is going to hold the first tier contracts with the lead design professional, with the prime constructor, whether it's a GC or a CMC, okay? And the owner can dictate, what insurance requirements need to be flowed down to the lower tiers. Now, it's not good enough just to do it right in the prime agreement, okay? You need to make sure that the subcontracts are written right, and you need to make sure that the insurance proof is right too, because having a claim against a party for not procuring insurance that they promised, it's probably not going to be very worthwhile, because the whole reason that we want the insurance in the first place is it's a source of financial backing to backstop an obligation where the party in contract might not have the funds to live up to it. So it's not good enough just to say, this is the insurance that I want you to have your subcontractors bring to the table. If I'm representing the owner or developer, I want to see the subcontracts, okay? And I want to see the insurance certificates and the endorsements in some cases to make sure, not just that I asked for the right things, but that we got the right things, okay? Which is the reason why there's almost never a day that goes by that I'm not talking to insurance brokers, because it's a licensed and regulated profession in the state of Illinois, very much like we lawyers have registration and licensure and CLE requirements. They know a lot of stuff that I don't, okay? There are hundreds of additional insured endorsement forms out there. I don't take CLE classes on which ones provide this coverage or that. So there's never a time, it doesn't matter who I'm representing, that I'm not saying to my client, I want your insurance broker involved in this discussion. And I want the insurance broker to answer two things. Number one, what kind of insurance does my client need to carry to satisfy its own needs? Which can be a much bigger question than just a project specific one, right? If the client's developing properties all over the country, they might have some kind of wrap-up insurance or business interruption insurance or something exotic, an OSIP, policy that covers, many projects, or similar types of exotic insurance. And I don't know enough about the contract, my client's overall operations. I just know about this one project. So I need somebody else to tell me what insurance my client needs for their own risks, but then I need to know what kind of insurance am I going to impose on the other parties and flow down. And the other reason why the owner needs to be in charge of this is because the property owner is ultimately going to pay for whatever insurance they want in contract pricing, right? An owner can say, I want better insurance. The contractor is going to say, okay, it's going to cost you more. That's just the cost of doing business. That's the way it works. The owner winds up paying for it, okay? And there's a few different things that we want to really focus in on. And number one is property insurance, okay? And so if you don't know about builder's risk insurance, understand the traditional property insurance that you carry on property that's not undergoing construction, say a homeowner's policy. It's not going to insure you for the risks of construction. Okay, that policy is there in case the Christmas tree catches on fire and burns the house down. That policy is not there for you turning your house into a construction project where there are cranes and people on the roof and people using acetylene torches. And so your homeowner's insurance and similar commercial property policies are going to say what's excluded is if you turn your project into if you turn your property into a construction site. So builder's risk insurance is the kind of property insurance that you would like to have. And it's not just there to protect the owner, it actually protects the contractor. Because if you think about it, when a project is underway, there's joint ownership of the project. The first day that the contractor goes out there and starts pouring steel and starts erecting steel and pouring concrete and hammer and studs together, the contractor still owns those materials. They have an insurable interest until the first pay app. Okay, when the insurable interest in what was built the month before goes to the owner. And so over time, the contractor owns less and less of the project and the owner owns more and more until the project ends. And then you transition off builder's risk insurance back to a standard policy. And because that property insurance, that builder's risk is there to protect not just the owner, but also the contractor, I see sometimes the contractor will buy it. I see sometimes where the owner will buy it. I don't really care as long as it's the right kind of coverage that's going to protect my client. But you better believe that the contract terms that I'm going to put in are going to vary depending upon whether my client's buying the policy or whether the contractor is. And there are similar things to consider when you think about professional liability insurance. Like the insurance that we lawyers carry, the insurance that architects and engineers carry, it's claims made, right? There isn't an occurrence trigger. So it doesn't necessarily do you much good if you're the owner or developer to have an architect that has professional liability insurance when the work is underway, if the claim is going to happen the next year. Because again, we all know as lawyers that we've got to keep up our professional liability insurance every year until we retire, and then we have to buy a tail policy because the question is when is the claim made? And so if I'm the owner or developer, I care not just about the kind of professional liability insurance, I care about how long the design firm is going to carry it. And my sophisticated clients are on top of making sure that the design firms do. Happy New Year. It's January 1st. I hope you had a nice New Year's party. I want your new certificate of insurance. I want your new endorsement. That's what the sophisticated parties do. They've got administrative processes to make sure that they've got the right duration of insurance in the contract, but then actually go and check up on that insurance to make sure it's carried. Like the insurance that we lawyers carry, professional liability insurance for design professionals, erodes with the payment of defense claims, okay? And so if you have $1 million policy on your project, with the architect or engineer, that's great, unless they have another claim on another project that eats that coverage up, okay? Or if you get into protracted litigation with them and the defense costs erode the policy down to nothing. So the limits that the design firm is going to carry are very important, okay? And because it erodes, sometimes in connection with a discussion about a limitation of liability favoring the design professional to the amount of insurance coverage, we wind up getting into a discussion about the design firm carrying project-specific insurance so that those limits won't be eroded by claims on other policies. All things that we have to think about in addition to, additional insured coverages, DGL insurance. And let me tell you, I am just scratching the surface of what could be a day-long conversation about insurance. There has never been a time in the last 15 years where I have not worked very closely with insurance coverage attorneys. Okay, I have a few favorites, a few pro policyholder insurance coverage attorneys that help my clients get the coverage they're entitled to. And there isn't a day that goes by that I'm not talking to an insurance broker to make sure that I have the benefit of their superior knowledge. Because the risk of loss in design and construction is high and frequent. I know when I get my contract signed and everything is copacetic and it's buttoned up right, I sleep better at night. It makes me feel good. As a litigator, I have been involved. I actually had a piece of litigation in the Circuit Court of Cook County that went on for 9 years. There were some non-suits and there were some, things that I could explain under other circumstances, but I really dislike that, because that's not what our clients want. They want early, cost-efficient dispute resolution. And the way that you achieve that is by having the right kind of insurance, the right kind of contracts, and then you get into a mediation where you can get an insurer there without any coverage defenses, okay, and you get the case solved. You get it settled in 3 months, not 3 years. I think that's what our clients want. So marrying up the right of recovery, which is a cause of action issue, with a recovery source, which could be a bond or a letter of credit or the right kind of insurance, is, I think, what our clients expect from us. This is typically where a lot of owners and developers start their analysis. They think about pricing, okay? And there's a number of different ways to price design and construction services. Lump sum, stipulated sum, fixed fee. They're not exactly synonyms, but pretty close. It's if you have an owner that is not interested in paying more than a certain amount, they're protected against the overrun, because if there is one, the contractor or the design firm eats the overrun. The flip side of that coin, though, is that if they're able to achieve some savings as they put the project together, the financial benefit of that does not inure to the owner, it inures to them, which is the reason why sometimes we get into the next one, which is not fixed fee, but it is reimbursement of the cost of the work, which is a very important term of art, plus a fee, okay? So a lot of you probably hear about cost plus GMP agreements, cost plus GMAX agreements, which are synonyms, they mean the same thing. And if you really want to understand how they differ from a fixed fee or a stipulated sum agreement, you have to dissect the full name of the delivery method, okay? It is that the owner is going to reimburse the cost of the work, which is actual costs incurred, plus a percentage-based fee, possibly up to a guaranteed ceiling. And so that might not get up to the ceiling. And then there's that savings, okay, which is potentially something that can get split between the owner and the contractor. So there's a potential way to capture savings. It's one of the upsides. Cost reimbursement plus a fee without a guaranteed maximum price. In some contexts, that's time and materials. In other contexts, it's a cost reimbursement agreement with no GMP, where the contractor has all the negotiating power. If you want to build a $15 million home, in a ski town out west, there might be only one contractor with the wherewithal to build it. And they might not give you a guaranteed maximum price because they got all the negotiating power, and they figure that you're a private equity guy with 15 million bucks to spend on your house. What do you care if it costs $1 million more? So, but very rarely would I accept an owner or developer not having a GMP because I need to have some price assurance. And then fixed unit price is used for, yards of concrete, things of that nature. So let's talk about the main options, and I'm trying to get this done on time. So again, price certainty. If you're lump sum stipulated some fixed fee, the design's got to be pretty complete, right? Because the contractor is not going to give you a fixed price if it has to guess at what wants to be built. It's much easier to administer the contract on a month-by-month basis because it's a fixed fee, and the contractor is going to bill a percentage of it each month based on completion. Anybody that can do first grade math can manage that. The disadvantages are, again, you can't fast track the project. You can't get started with construction in most cases if the design's not complete, if you want the contractor to give you a fixed price. Because if the contractor's got to give you a fixed price and it doesn't understand the design intent, it's going to stuff in all kinds of extra dollars in there to hedge against the risk that they're guaranteeing the fixed price. There's no potential for the owner to realize savings, and it's difficult to align the incentives between the owner and the contractor, which is really important, which I'll elaborate on now. If we talk about a cost reimbursement contract, again, the owner pays the contractor the cost of the work plus a percentage-based fee, possibly with a guaranteed maximum price or not. Okay, what are the considerations? If you have no GMP, you have no price assurance, there's no ceiling on what you're gonna have to pay, and you have a contract that's much more administratively difficult and contractually difficult. And if you have the GMP, which sets the ceiling and invites there to be maybe that savings that could be split up, you don't have the lack of price assurance, but you've got a contractually and administratively difficult agreement compared to a very simple fixed fee agreement. So what are the advantages? You can fast track the project on a guaranteed maximum price project because you can just amend the guaranteed maximum price as the design gets complete. That's frequently done. So you can get a shovel in the ground quickly if you need to. The contractor can get a shovel in the ground without giving you a fixed price. That means it doesn't need to hedge against unknowns by stuffing its fixed price with all kinds of contingencies. Okay, there is that potential for the owner to realize savings, and you can align the owner and the contractor's interests through those shared savings. And what that means is, it's just a real simple example. Take a contract that would be for $10 GMP. The contractor knows that it can get the project done for $9, okay? But maybe it could spend another dollar on steel or concrete or something like that because its fee is percentage based. It's incentivized. I get a 10% fee. I'm going to go spend that extra money on the steel because I want another dime in my pocket. Well, if the owner is smart enough to share some of those savings, maybe just for simple math, splitting it 50-50, if the contractor decides that it can bring the project in for $9 instead of 10, it saves $1 on steel instead of spending it. The contractor doesn't get a dime, it gets 2 quarters. Okay. And so that makes the contractor want to save. It aligns incentives, and that's how an owner can align its incentives with the contractor through shared savings. Now, if you don't do the shared savings the right way, you get down into the disadvantages on the slide. What incentive would they have to finish the project underneath the GMP? They're going to go all the way up to the GMP if they can justify it, because it's going to mean more fee for them, so they might have less incentive to complete the work quickly and efficiently. It's much more contractually difficult. The standard AIA agreement, it's 8 pages longer when you go from fixed fee to cost plus reimbursement, because the definition of the cost of the work, which is code for what the owner will pay, it stretches for pages. And so, you got to really look at that definition of the cost of the work, because if you're not careful, if the GC flies its whole team to Tahiti and they have a conversation about your project, you might get the bill for their airfare if you're not clear about what is outside the cost of the work. And there's myriad other considerations that goes into a good definition of the cost of work. It's more difficult to administer monthly on payout basis because it's not just percentage of work complete against a fixed fee, it's actual costs. And then at the end of the project, the owner typically has the right to audit the contractor's costs with professional auditors, which introduces a whole level of complexity, at the end of the project. And this all tends to invite claims. So all things being equal, unless there's a really good reason to prefer a cost reimbursement contract, I tend to prefer that my clients go a fixed fee, but I negotiate lots of them. All right, so the last part of our discussion here is design and construction contracts. And I'm trying to think. I started at 12:30, which means that I have a little bit more time here, I believe, to carry forward the presentation. I wish my owner and developer clients would spend more time thinking about all the things that we just discussed, rather than sending me an email saying that I've got a project that's mostly baked in the oven. Here's a contract form we've already selected. The other side's already marked it up. Now I want you to fix it. And believe me, I can fix it. It might involve me, giving it a lobotomy or adding a lot of terms. And, nobody likes when we overcomplicate things. And I'd like to think that perhaps that's not so much my fault as the fault of people that didn't give thoughtful consideration to some of the things we've already talked about. But let's talk about standard agreements versus custom contracts. And again, custom contracts, when I took the bar exam, I hated those essay questions because I hated the blank piece of paper and the risk that you run. If you're not using a standard agreement, like an AIA contract, if you're using a custom contract put together by somebody, how equipped are you to look at it and diagnose what's not there? And that's not easy to do. I have developed checklists over many years where, I'll just go down the list and say, okay, I want the contract to have these 150 features. This is not a standard agreement. I'm going to compare it against my checklist, and I can see immediately that we're missing 30 things that I need to get in there. So if you don't have sort of the ability to spot those sort of Rumsfeldian unknown unknowns, that's one of the risks of using a custom contract. There are many standard form agreements, not just the AIA ones that many of us are familiar with. And you have to consider who writes them and is there any bias? And I don't mean this in a pejorative way, but the AIA contracts, and I am a little bit biased myself because I work very closely with the AIA. I was talking to its general counsel about this presentation, 2 days ago. So, I'm not perhaps entirely unbiased myself, but the AIA contracts carve out a very large role, okay, for the design professional. They have the architect looking at payment applications, observing the construction as it happens. And is that a good thing or a bad thing? I don't know that it's either, okay? If your developer client is very sophisticated and they've got the internal ability to administer the construction contract, maybe they can go without the benefit of having the design firm in their corner, keeping an eye on the contractor. But if your client is a private equity mogul that's building one of those $15 million palaces out in some ski town, chances are that person does not know much about design or construction, and there's a real benefit to having the design firm involved in administering the construction phase of the project. And so the AIA agreements have a very substantial role for some delivery methods, not all, but for some, where the design firm is going to be heavily involved. That can be a very big advantage for the occasional or infrequent consumer of design and construction services. Consensus docs, by contrast, which is it's a very highly regarded set of documents that's put together by some very smart people. It's newer. The AIA contracts have been around for more than a century. Consensus docs have been more over the last few decades. They are fair, and I'm not arguing that they shouldn't be used, but I will point out that they don't have as great of a role in the construction phase for the design firm, as the AIA contracts do for some project delivery methods, because a lot of the driving force behind the consensus docs are people that are more contractor types. That's not entirely true, because both the AIA and consensus docs, they've got input from a wide variety of people, all different segments of the industry. Consensus docs takes input from designers. I'm not going to say otherwise, but you have to consider what is sort of the philosophy, and is there any bias built into these agreements? And I don't think any are better or worse than others. And something that I heard a really smart construction attorney once say was that all these standard form agreements are just the starting point for negotiations anyway. So if somebody wants to present me with any one of these forms, I don't care, I can fix it. But if I'm the owner or developer, I think would prefer to come out of the chute with a good contract written on a form that would serve my particular needs. How do you select the agreement? You think about these things, okay, which is probably really abstract and not much value to a lot of people until you begin to click forward in a few of these slides and you realize that just looking at the example of AIA contracts, because it's what I'm most familiar with, there's a whole lot of different owner-architect agreements. I'm just scratching the surface of them with what I have listed here. Owner-architect agreements are denoted by a B, and owner-contractor agreements are denoted by an A. And if you're looking for an owner-architect agreement, do you want the B101 or the B103? Well, you need to know what they say and their differences, but you need to balance the complexity of the project and the need for contractual protection. You don't want to overdo it with a contract, but you also don't want to underdo it and have a lot of gray areas that are going to invite claims that are not easily resolved and need to go on and be litigated. Looking, at the contract documents of a traditional project, I want to point out in particular the role of the AIA A201 General Conditions document, which I think is perhaps the most ubiquitous contract document. I don't have any data on this, but I bet you that if you did a survey of every construction project in the United States and you said which contract document is most commonly found, it would probably be the A201 General Conditions, even though it concerns the architect in a major way. It is technically part of the owner-contractor agreement because of a sequencing issue. In many cases, the architect is hired first. And so the owner and the architect wouldn't want to negotiate the A201 and then a year later have a contractor come in after bidding and be unhappy about what it says. So the A201 General Conditions typically sits out there until the owner-contractor agreement is negotiated. But we know through the magic of the word search function in Microsoft Word that the word architect appears 309 times in the A201 General Conditions. And so to say that it's not a part of the owner-architect agreement is, again, slicing the bologna awfully thin. And we all need to understand where and when it comes into play. And you're going to see on the next slide an orange box that depicts the General Conditions document, okay? So this looks complicated, but it's not. Lines represent contracts. So you can see this is the traditional design bid build or tripartite method of project delivery. If you look in the upper right-hand corner, you can see that there's 54 AIA contract documents in this particular family. I've not listed them all here. And you can see that the owner is in contract, if we focus on the left side of the diagram, with the architect directly. Okay, and you can choose from a wide variety of contracts in the B series. If you look to the right of the owner, you can see that the architect is in direct contract with the contractor as well. That's when the A201 General Conditions matters, okay? When the owner is in direct contract with the architect and the contractor, the A201 General Conditions sits in the background and says things like, here are the circumstances under which an architect could reject a pay application. Here are the circumstances under which an architect could order the contractor to open up a wall so that they could see what's inside. Okay, so you need to understand when that orange box is going to be there. If you look to the top of the owner, you can see that it may make sense for them to have some direct consultants. Maybe that's a criteria professional. You see the dotted line to the surety if there's a bond, in place. And so, this is what the traditional design bid build project delivery method suite of contracts might look like. This is one of many options, but watch that A201 General Conditions box is about to disappear in the next slide. You see it's not there anymore. And if we were in my construction law class at John Marshall, I would make the students tell me why. But since this is not interactive, I'll cut to the chase. The answer is because the owner no longer has a direct contract with the architect and the contractor. The owner has a contract with the design builder. Okay. And in those circumstances, the A201 general conditions becomes irrelevant because there is no need for there to be that document that explains how the owner and the architect and the owner and the contractor are all going to play nicely in the sandbox together. And so if you look at this diagram, you could see to the left, maybe the owner wants to have a direct consultant like a criteria professional to protect it against the risk that it does not have a direct contract. There's no direct line between the architect and the owner. So, if the design builder is proposing value engineering changes that the architect considers to be unwise, the architect's got that moral hazard, that conflict of interest. It might not be at liberty to say to the owner, that's gonna be like a pixie stick, a quick sugar high. You're gonna feel happy when your project comes in, on time and on budget, but you're really gonna not like the life cycle performance of this building in 10 years. So, there's lots of different things to consider, lots of different contract forms to consider, not just in terms of the pros and the cons of all the various delivery methods and how you arrange the chess pieces and the terms you put in and insurance that you talk about. You need to think about what your options are for contract forms that are out there and how you might customize them. Construction manager as constructor. I said that this delivery method, CMC, is a lot like when the owner hires a general contractor. And that is the reason why we once again have the A201 general conditions box in the background, because once again, the owner has a separate contract with the constructor. It just happens to be a CMC instead of a GC, and it has a separate contract with the architect. Okay. And if you look at the CMC, you can see that they've got obligations in a pre-construction phase and a construction phase, because in that pre-construction phase, they're whispering in the ear of the designer about cost and constructability and different systems. And so, there's this advantage about having the CMC involved during the design phase. The owner may have direct consultants as well. And if we click the next slide, you will see something that looks complicated, but it's really not. Let's look up from the owner. You can see that there's the option for them to have direct consultants. Look to the left of the owner. There's nothing complicated there. It's a different B series agreement with the architect because this is a construction manager advisor project. Some of the traditional role of the architect might be filled by the CMA. Nothing complicated about the idea of the architect hiring the consultants underneath them there. Okay. You could see to the right of the owner, you've got the C-132 contract between it and the construction manager as advisor. And what may look complicated, but really isn't, is if you look down from the owner, you could see multiple prime contractors. And I told you at the beginning that if you're going to do multiple prime contractors, an owner may very well want to have a CMA there in order to provide that communication and construction management, which is why you have that dotted line underneath. And so many ways to pick delivery methods, so many things to think about which one's best, what terms do we put in, what insurance do we need, what do we think about pricing, what's the owner or developer's goals, but then you have to actually get the contracts in place, which is what we're addressing now. I could have many more slides than I'm going to have here, but I want to point out that there are documents where the project is interior design and fixtures, furnishing, and equipment, because here the owner is going to have a direct contract with the GC and the architect. So once again, you're back in A201 general conditions land, but the FF&E vendor, somebody might be buying millions of dollars of furniture and furnishing and equipment. And so the owner is in direct contract really with almost like two contractors here. And that changes the role of the architect. So you've got all these different families of documents. This particular one, if you look on the right-hand side, it's got 54 documents in it. So I'm certainly not showing you all them. Real quick, we're going to get into integrated project delivery at a very high level because I doubt most of you will ever encounter this. Integrated project delivery is a cutting edge method, more of a sliding scale, as I mentioned earlier, where, some of the things that make design and construction risk prone and dispute prone and litigation prone, the smartest people in the industry are trying to figure out how to get that out. of the way that we're, building. And so maybe 50 years from now, it's going to be all integrated project delivery. But if you want to just kind of put your toes in the water without jumping all the way in the deep end of the pool, a light version of IPD might look something like this. You have a different general conditions document that's not the A201, it's the A295, because it's a different kind of a project, but you can see the owner and direct contract with the architect and the contractor. And this is, the next slide's the one that I love the most, because this is the one with the multi-party contract. Look at this, okay? Under a multi-party agreement version of IPD, you've got the owner, the architect, and the contractor in a multilateral contract, the C191, where they're all contracting parties, and it boggles my mind to even think about this, because every piece of litigation I've ever handled would be just upside down and inside out if there were three parties to a contract, three contracting parties. So this is not for the faint of heart. And if you wanted to do a project like this and you were not very sophisticated, simply out of my own sense of self-preservation, I'd probably tell you no, because I don't know that I'm willing to even get involved in this. And another variation on this, which is pretty extreme, is if you have the owner, architect, construction managers, and others create a single purpose entity that is then going to go hire all of the members of the SPE to do their own things. This is integrated project delivery, the single purpose entity method. Again, you better know a heck of a lot more about design and construction than I do if you want to do this, because this is not for the faint of heart. If I spend a lot of time working on this, it'll be maybe, when I've got a heck of a lot more gray hair. If you want to know more about all these different AAA contract documents, this is the website that you go to. This is the first of a bunch of clickable links in this PowerPoint. So if you do not have a copy of this, you can get my PowerPoint by emailing me. You can see an email address, in the slides. My website's at the bottom here. You can also download it from the CVA website. And so what's the conclusion of all this stuff? It can be complicated, maybe more so than people, realize. And so don't skimp on thought of the project delivery method. How you arrange the chess pieces is going to dictate what the contract should say, which forms you should use, what kind of insurance is necessary. If you begin with the end in mind and you negotiate with a litigator's mind, you can make sure that you marry up the right with the remedy, so there's a pot of gold at the end of the rainbow. And if I do it right, God forbid there's a claim, I look at the suite of contracts and I say, great, I'm going to fire off a letter to a party that's going to have insurance. There's not going to be a reservation of rights because there's going to be coverage. We're going to get to a mediation. I'm not going to be trying to open a door that won't open because it's got no doorknob or hinges, and we're going to achieve early cost-efficient dispute resolution in 3 months and not 3 years, which I really believe is what our clients want from us. And you can see from my enthusiasm that I think all this stuff is tremendously fun and interesting. There are not many people that feel that way. A lot of my clients think this stuff is not fun. And for them, the fun is when they get to design and build. One of the things that I struggle with is trying to make simple what's complicated, because my clients hate when I overcomplicate things. And it's the sort of challenge of my career, trying to take all this complicated stuff and make it look right without annoying people too much. On my website, I have a ton of content. I try to add 4 new videos every month. I'm thinking about maybe shooting 4 today. I don't know what they'll be about just yet, but I talk into the camera sometimes for as much as 10 minutes. So if you get an actual copy of this PowerPoint, you can click those blue links and it would take you to some of my videos that talk about some of the things I've talked about today. This is not close to the number of videos on my website. I also try to add lots of relevant articles. So if you're interested in stuff and maybe it's not relevant to your current project, what you care about now, and you want to save this slide deck to maybe come back to it, here are some resources for you. And I got a lot of other stuff on my website that you can look at, because I'm big into cost-efficient dispute resolution, do a ton of mechanics lane work and all this other stuff. I do a monthly newsletter the last day of the month where I put in all my new videos and content. It's free. If you want to sign up, you can click that link there. And right at just short of 1:45, I want to thank the judge and Nicholas and the committee for allowing me to be here today. And I want to thank everybody that was a part of this presentation for giving me an hour of your time. Thank you very much. And that concludes my presentation.
Jeremy, that was great.